So my name is, just some introductions. My name's Stephen Humphreys. For those of you that don't know me, I'm a partner, a solicitor at Ashford's LLP, and I lead on our energy consenting work as well as some of our wider, bigger infrastructure projects. And I'm joined today by my colleague, Laura Kiy. Laura, I don't know if you want to just say hello so people can see you.
Yes, hello and welcome everybody. Thank you for joining us this afternoon. I'm a solicitor in the planning and infrastructure consenting team at Ashford's.
Real, thank you. And the purpose of today is to talk about the new regulations which are linked to the Infrastructure Wales Act. Now we will go through the regulations themselves, but just to flag, we are talking about the regulations, not so much the Act itself. The Act is the framework, and the regulations are some of the detail that support the Act. Inevitably there'll be crossover, inevitably we'll be discussing some points that are in the Act, but just to flag that that's kind of our approach. And one point, seeing as I've got everyone, and we always give a bit of a plug inevitably, so do forgive me, but for those of you who don't know much about Ashford's and our energy consenting team, so we've been engaged in a lot of DNS projects, developments of national significance under the current regime. We've been advising on it since 2016 and have advised on about 20 to 25 DNS projects, all for promoters, developers. And we've also done lots of responses to consultations, particularly on behalf of and supporting Solar Energy UK. We're working on a lot of renewables, predominantly solar and wind, sort of 0.5 gig of solar and probably over about 700 meg of onshore wind. And we've also got a lot of experience on the nationally significant infrastructure project NSIP side. Again, the team's got a lot of experience having worked on nuclear, roads, rail, onshore wind when it was in, but now it's back in. So we've got a lot of experience, and it's helpful because today we'll see a lot of crossover between those regimes. Frank, could you move the slide on, please? So we're going to be transitioning from the DNS regime into the new ICO regime. As I say, we're talking about the regs which are coming into force. They're coming into force on the 15th of December. And one of the regulation, or one of the orders, I suppose, it's not a set of regulations, but it is a statutory instrument. The Infrastructure Wales Act commencement number 1 order is also coming into play on the 15th of December, and that will turn on most of the Act, not all of it, because we're still waiting for some of the regulations to come into play, particularly around revocation and modifications. I think challenges as well, but Laura will speak to that later. In terms of the orders themselves. So we're going to go through those, and fundamentally there is going to be quite a considerable shift in the way that things are done in Wales. So the new regime, it covers energy, transport, waste and water, and you'll all have seen it's supposed to be a one-stop shop. It's the best bits from DNS, it's the best bits from NSIPs. I think DNS was always seen as a bit of a stopgap, and that was predominantly because of timings and also devolution, because the DNS regime was introduced before the Wales Act of 2017, which devolved more powers. And a fair amount of that did also relate to not having powers in the realms of things like compulsory acquisition. So that's all now being accommodated for in this new regime. I said earlier that we've got more detail, we've got more sort of flesh to the bones of the Act, but there's still a big chunk missing, and you've probably seen that, and I think it was confirmed yesterday in the Senate, that guidance will be issued in respect of the new regulations. Now the way the regulations are set is they do leave a lot of discretion to Welsh ministers. They do leave a lot of discretion in their name, to PEDU. So we do need a fair amount of guidance. And today we're giving you our view on how these regulations will apply, with the benefit of that, working with the DNS regime and also working in the NSIP regime. But some of the clarification we do need in that guidance document, so we're still waiting for that. So we won't necessarily be saying goodbye to the DNS regime, obviously, because there are transitional arrangements in place. The big one is really that I think there'll be quite a fair few people sort of scrabbling around trying to get into the DNS regime and not wanting to use the ICO regime. That won't be the same for every project, of course, but I think the general consensus is that the ICO regime will be more intensive from a procedural perspective and also from a resource perspective. So if you want to benefit from the DNS regime, then it's sort of notifications that need to go in before the sections 19 and 20 of the Infrastructure Wales Act are turned on through that commencement order, which happens on the 15th of December. So the DNS regime is still going to be around. It's still very relevant. I must say, I've always been I've been a fan of the DNS regime, perhaps not at the beginning, but it has worked its way forward, and it has, it has seen consent being issued. So I think we've had about 42 decisions, and about 75% of those have been consented. I think there's been 7 or 8, 9 refusals. Of those, a couple have been judicially reviewed and been submitted back for redetermination. So it was a slow start, but it has felt like it's been working. And now, just as it sort of reaches its kind of crescendo, it will be replaced. But it will remain very relevant. So we shouldn't just dismiss the DNS regime as being dead. And it'll be relevant in the sense that, from a policy perspective, under the new Infrastructure Wales Act, there is the provision for infrastructure policy statements, much like national policy statements in the Planning Act. There is provision to have those, but the Welsh Government has said they're not going to introduce them, and they're going to rely on existing policy. Well, a lot of the interpretation around that existing policy is in the DNS decisions. So they will still remain relevant. And, another plug, of course, it would be helpful to have people on board that know about that background and understand how policy has been applied to date. So fundamentally, with this change, which is, the intention there is supposed to give more consistency, certainty, improve delivery, improve net zero ambitions and infrastructure. I'm going to talk, inevitably, we talk a lot about energy projects because they are the ones that have predominantly used the DNS process. But there are obviously, this is going to take over, Transport and Works Act approaches, Harbour Act orders. There's a lot more to this than just sort of a switch from DNS to SIP or ICOs, sorry. It's going to encompass a lot more. And I think a lot of that really does need to be emphasised because from my own perspective, as I say, having worked on DNSs and NSIPs, there's a real big shift that needs to happen from a mindset perspective. Because a DNS is an application for planning permission, and it's an application for full planning permission. So your level of flexibility, your level of detail is flexibility less, detail more, and probably quite a limited, apart from micrositing conditions or managing to get a condition through that does say some details can be signed off at a later date through the condition. Under the new ICO regime, you have a lot more flexibility. It's not an outline planning permission approach, it's a statutory order. The original schemes that went through under the Planning Act 2008 for the NSIP projects, perhaps some of those did feel a little like outline consents because the level of detail that was required was much less, frankly, than it is now. And I think there's a bit of a theme there, isn't there? Because we seem to see examining authorities, inspectors, local authorities just trying to get more and more detail out of applicants to make sure that any potential for change or sort of any unknown is covered off in the detail at the time of application. That's not going to be the case with ICOs. With the flexibility, introduction of limits of deviation, much like you have in DCOs, in Transport and Works Act orders, the concept of the Rochdale envelope process will be accepted because that's the way the process is set up. Obviously, that's not permitted, and PEDU don't like it in the DNS context. They don't even like alternatives that much, although I'm aware of a scheme that has permitted alternative, I think, accesses or grid routes. But the limit of flexibility is very much there. And there would be more work, unfortunately. I must say I've not been a necessarily big advocate of the ICO regime because it does entail a lot more detail from a just from a documents perspective, not necessarily sort of time yourself in the way you would for a full planning permission, but just the level of detail around new documents you need. So you have works plans that show limits of deviation. If you're going for compulsory acquisition, which you can do now, you'll be throwing in your land plans, your statements of reasons, your book of reference. And obviously all that's got to be reviewed, not just by your applicant team, but also by third parties, by local planning authorities, NRW, CADU. They're all going to be looking at these documents and they're going to have to consider them and comment on them. And moreover, they're going to have to consider, which we'll talk about at the end, an infrastructure consent order. What does it look like? I think pretty much the consensus is that your ICO is going to look like a DCO. So, whoever's drafting the first one, unless in the guidance document from Welsh Government, they provide model clauses or they provide an example draft. But fundamentally, you're going to end up with what will, I suspect, be quite a complicated document that can cover compulsory acquisition. It can disapply other legislation. It can have deemed consents. It can extinguish consents. So all of that, and obviously a lot of that needs to be considered by developers before they start on this process, because you want to look at the lists and see what things you may need in order to deliver that project. But you're going to have third parties who are going to have to review these documents and understand those powers and then comment on them as part of pre-application consultation into their local impact reports as well from the local planning authority perspective. So there's a big shift, and I think that's really, I've spoken about it probably enough now, but I'm saying it because I really do think that the mindset shift is one of the most important things about this process. It really is a step change. So if you could go to the next slide, sorry, please, Fran. We're now going to go into the detail, and I shall hand over to Laura, who's now going to take you through the detail of the regs. Thank you.
Thank you, Stephen. Just up on the slide here, we've got a quick reminder of the types of development that will be subject to the ICO regime. I don't propose to go through those in any detail as they've been published in the Act for a while now. But just to highlight again, really, that the amount of projects included here means that the new regime is likely to be used a lot more than the DNS regime currently is. And it's evident that in the drafting of the Infrastructure Wales Act, there's really been a consolidation exercise to make it clear that there's now a single process for a larger number of projects, rather than applicants having to pick and choose between different consenting regimes. So just examples of the thresholds that will apply. So energy projects with generating capacities of between 50 and 350 megawatts. Electric lines, the new regime will apply to installations with a nominal voltage of 132 kV, providing the line is a minimum length of 2 kilometres, and highways of more than 1 kilometre. So if we could go to the next slide, please, Fran. So what do the new regulations actually cover? So we've got 5 new regulations, essentially putting most of the meat on the bones of the Infrastructure Wales Act. I will go through more details in a moment, but just to flag that there's a lot of crossover between the regulations themselves and a lot of cross-referencing. So we recommend, and it is really important if you haven't already done so, to read each of the regulations alongside one another rather than seeing them as individual statutory instruments. That's particularly important in relation to the compulsory acquisition regulations and the miscellaneous provisions regulations, which set, among other things, different timescales for different stages of the ICO regime, where, for example, an application includes or is varied to include a compulsory acquisition request. So I have flagged some of those throughout the next few slides, just to make you aware of the key points where those timescales do change. So just running through what the regs cover very briefly, and it is pretty self-explanatory, really. So you've got the pre-application and application procedure and transitional provisions, which cover notification, pack, application requirements, validation of applications by Welsh ministers, local impact reports, and all of your transitional provisions relating to pack, which I will come on to at the end, because there's some quite knotty detail to go through on that. Then the examination and decision procedure regulations, covering the appointment of examining authority decision making, open floor hearings, the procedure for examination, written statements, reports, and notification of decision. And then the fees regulations, which we don't really cover. There's not a huge amount of detail to go through on that at the moment, but just flagging up there that all of the fees for each stage of the regime will be set out. And then compulsory acquisition, as I said, it's really important to read that against the other regulations because they contain additional and supplementary procedures that will apply to all stages of the application process. And the same again with the miscellaneous provisions, and they also include the power to disapply provisions of the Act, requests for pre-app services, requirements for pre-app meetings, removals of consent, deemed consent, and the procedure to be followed for requesting a Section 22 direction relating to optional SIPs, which Stephen will talk about later on. So if we could move on to the next step, please, Fran.
Do you mind, sorry, just one thing I'd just add in is that the fees, the order essentially just says everything's going to be set out on a website to be maintained by the Welsh ministers. So I haven't seen any clarity on what the costs will be, albeit they will relate, as the Welsh ministers have always said, to full cost recovery from memory. So we'll have to see what those figures are when that website's published, and at the moment don't actually have a date for that. So watch this space.
And the next slide again, please, Fran. So I appreciate that the content of the regulations is quite dry, so I'll try to keep it as light as possible, but just want to pull out the main points that everyone needs to be aware of. So starting with the applications regulations, these are the key regulations of the pre-app and application stages. A lot will be familiar from the DNS regime, but I think it's still important to pull out the main detail just to see how this compares and how it all fits together. So applicants kickstart the process by submitting a notice of proposed application to the Welsh ministers. Where Welsh ministers decide to accept the notice of proposed application, they need to give a notice of acceptance within 14 days to relevant statutory and specialist consultees and any other persons identified under the corresponding provisions in the Act, which essentially will be all of the same parties on whom the notice of proposed application was served. Applicants then have 18 months from the point that Welsh ministers give their notice of acceptance. Now, this timeframe may be extended by up to 56 days, for example, where a relevant statutory consultee has raised concerns about the proposed development and to such an extent that it would object to the application as made. This is also our first example of where the compulsory acquisition regulations make further amendments to timeframes. So under the compulsory acquisition regulations, where additional interested parties are identified in relation to proposed applications which include compulsory acquisition requests, then a further extension may be granted by the Welsh ministers of 49 days. So you could end up with 18 months plus 56 days plus 49 days if those boxes are ticked. Regulation 9 of the miscellaneous provision regulations, and again another example of where it's necessary to read kind of the miscellaneous provisions regs alongside the application ones and the examination and decision regulations. So regulation 9 sets out how a request for pre-application services made to a planning authority, NRW or Welsh ministers may be made, and what that request should include. Regulation 10 of the miscellaneous provision regulations then sets out how requests should be accepted and confirms that the date by which the pre-app services are to be provided should be no more than 29 days after the day on which the notice is given. Any requests for pre-app meetings given by applicants should be confirmed within 15 days of the day on which the request is received. In relation to what needs, so there are quite extensive requirements set out depending on the location of the development and what you need to include in terms of your request. So, for example, whether it's in Wales or in the Welsh Marine area, and corresponding information that needs to be included in any notices to be served. Although Section 32 of the Act provides that a draft ICO is required when an application is submitted, Regulations 6 and 15 relating to the requirement to publish and maintain a website and application documents don't include any reference to that at all. So that's unclear. And again, we'll come on to that at the end of the presentation. So statutory consultees are now obliged to provide a substantive response to a pre-app consultation, and that's within 42 days again of receipt of the Welsh Minister's notice of acceptance. Welsh ministers will give notice of a valid application as soon as practicable after acceptance of an application. That phraseology appears quite a lot throughout the regulations. It isn't particularly helpful, although I think, as everyone's probably thinking and hoping, the guidance will provide more information. And obviously the first few applications that go through the ICO regime will set expectations as to what the time frame could be, and will hopefully tease out any issues that may arise from any perceived lack of certainty that may need to end up being addressed in any further guidance. So again, there's a 42-day period in which applicants have to consult with statutory consultees, and there's quite a lot of discretion in terms of any other period that may be agreed in writing. That's under Regulation 27. So that's one to watch out for as well if that timescale does get increased. Then local impact reports are dealt with under Regulations 28 and 29. Planning authorities need to make sure that the requirements for contents of local impact reports are satisfied. So, for example, including a description of the relevant planning history of the site, any relevant local designations, the likely impact of any application in relation to a deemed or extinguished consent. And reports also need to contain confirmation that the planning authority has complied with any Section 130 direction, which requires them to notify certain persons and to publicise the application. So then we come on to the variation of applications. Now, under Regulation 31, to us, the drafting doesn't seem very clear at all. So it states that applications to vary, or requests to vary an application, can be made before the end of 14 days, beginning with the day after the deadline by which Welsh ministers must receive representations on the request to vary the application, which isn't very clear. So what we actually think it should state, whether this is right or wrong, we don't know, is that if an applicant wishes to make a variation to their application, then it needs to be done before the end of 14 days of the close of the initial representations period, which would reflect the current DNS process. But the drafting isn't clear, so I think we're going to look to try and get confirmation on that and what that should actually, what it should state. But that aside, Welsh ministers will then give their decision on whether the request is approved within 7 days. The applicant will then have a further 28 days to submit the varied application. And it should be noted that Welsh ministers will not accept a request to vary an application where the effect of that variation would be to substantially change the development for which infrastructure consent is sought. Then jumping back a bit to PAC, the regulations do kind of jump around a little bit, but Regulation 32 sets out the transitional provisions for PAC. I believe there was a question that was submitted on this topic, and I can't say that I'm surprised because the provisions aren't very clear, and it does take time to kind of to work through them and unpick them and actually understand what's going on. So essentially, it will not be necessary to repeat PAC if it's already been completed in the 12 months prior to the 15th of December 2025, and the PAC requirements of the new regime have been complied with as if they were in force at the time. But there are some nuances to this, and what I'm going to try and do is to unpick the regulation now. So Fran, if we could move on to the next slide, please. So this is a screenshot of the regulation itself, and I just want to walk through it because I must admit, when I had to read it quite a few times to understand what was going on and which dates applied, what timelines needed to be complied with. So the transitional provisions will apply to applications that are made in the 12-month period beginning the day after the regulations come into force. So the 12-month period beginning on the 16th of December 2025, where those applications went to PAC in the 12-month period before the 15th of December 2025. Now that's on the proviso that the applicant has consulted the persons in Regulation 8 or 10 as appropriate, and the applicant has publicised the proposed application in accordance with Part 3 of the regulations, which deals exclusively with pre-app consultation and publicity, as if they were in force at the time. Then the requirements of Section 30 of the Act, which sets out the obligation on applicants to carry out consultation and publication of the proposed application, will be met. So you will have satisfied PAC requirements under the SIP regime. So applicants intending to rely on these provisions must notify the Welsh ministers of the proposed application before an application is submitted, but then they won't need to comply with the notice of proposed application requirements set out in Regulation 3. So these provisions will essentially be in place to prevent applicants from having to carry out PAC twice in certain circumstances, where I think there could be a bit of difficulty or frustration is in the second 12-month period. So the 12-month period before the regulations come into force is slightly deceptive, because applicants can't reasonably be expected to have complied with provisions that they haven't had visibility of. So it's probably more likely to apply to applicants going to PAC now that the regulations are in circulation, unless you're incredibly lucky and have happened to have followed the ICO PAC process without realising it. I hope that's helped, but we can discuss at the end if you've got any further questions on that. Okay, so if we could have the next slide, please. Okay, so the examination and decision regulations. So we've got the procedure for the appointment of the examining authority set out in Regulations 3 to 5. Open floor hearings are a new entry into the process. So the consultation that was published back in September 2024 initially proposed that open floor hearings would be held upon the request of at least 10 people. So obviously this number has been significantly reduced in the regulations, and will now only require the request of one person to trigger an open floor hearing to be held. The examination procedure will be determined within a month of the closure of the representation period, which will be set out in the Welsh Minister's Notice of Accepted Application. And again, just a brief note here to be aware of slightly different timescales where an application has been varied to include a request to authorise compulsory acquisition. So the period in that circumstance, the period will then be the latest of those 28 days, and the 28-day period for beginning with the day specified for representations to be made on the variation of that application to include a compulsory acquisition request. Hearings and local inquiries must begin no later than 10 weeks from the closure of the representation period. Applicants will receive written notice of when those will be held 6 weeks in advance of the start date. Another addition to the process is that hearings may now be recorded and will be made available at the request of any person until the end of 6 months, beginning with the date that the application has been decided. We touched briefly on the ability for applicants to vary applications to either include additional land under the compulsory acquisition regulations and where a variation is requested prior to the determination of the examination procedure, there is a further opportunity to vary an application once the examination procedure has been determined. And in such a case, applicants need to give the examining authority as much notice as reasonably practicable. But in any event, that needs to be before the first day of a hearing or a local inquiry. And what's really important here is that the applicant must include reasons why the effect of the variation was not included in the application as made, and why the request couldn't be made earlier in the process. And applicants will also need to set out why the request could be examined within the time for deciding the application. So there needs to be a reasonable belief that the variation is not so substantial that it would result in a delay in the process. And then finally, just to finish off, as we already knew since it was set out in the Act itself, decisions on applications must be made within 52 weeks, beginning with the day the application was accepted as valid. So that's a whistle-stop tour of some of the highlights of the regulations. I'm going to pass back to Stephen now to talk about optional SIPs.
Thank you, Laura. I think as well, it's just worth saying that the 52-week time period is the sort of holistic time period, and aside from some confirmations around, you know, when you get your notice of acceptance back and you get issued what I think I'd call the timetable, the regulation 11 notification from the EXA, which is a timetable for examination. In that regulation 11 timetable, they are supposed to say the date by which they expect to issue their report. So to be honest, I'm working on the sort of 6-month examination, 3-month recommendation, 3-month Welsh Minister's decision approach, but that could change. And in almost every single one of these regulations, there is scope to change those timescales, as Laura mentioned earlier, as soon as reasonably practicable, or unless the Welsh Ministers decide otherwise. I mean, there's one of them which I think looks at must be done by 28 days. It can be extended by 14 days in limited circumstances, but those timescales can be increased to any time that the Welsh Ministers decide fit. So you end up in a situation where, to be honest, trying to give you some indication of timescales, and this is a big concern, really, predominantly because, as we all know, the NSIP regime has got a good success rate, and the likelihood, although I know it's happening a bit more now, particularly in the pre-examination phase for NSIPs, but very unlikely examination period for an NSIP will be extended. It's only really happened in well, I mean, I was working on one of the first project I think that was extended because of COVID, obviously, and that's understandable. But other schemes that were so enormous and asked for requests, like Hinckley from memory, didn't get it because they said no, it's the most important thing to have this certainty. Because I just don't think we're going to get that with the way these regulations are drafted. And moreover, resourcing, of course, you know, how many DNS projects have been suspended? I think every single one. So when people are looking at this, when they're considering the issues raised, when they're considering, as I mentioned at the outset, the kind of technical detail and the legal detail that's going to be part of this process, I think that just ultimately will be quite a few delays. So I would take timescales flagged as a bit of with a bit of a pinch of salt in terms of how the scheme operates. So yeah, I was going to talk to the optional SIPs, which are in the miscellaneous provision regulations, and I think these are really important because they've frankly raised a lot of concern. We've got sections 22 and 24 of the Infrastructure Wales Act essentially set out the overarching powers. And it's regulations 4, 5, and 6 in the miscellaneous provision regulations that deal with essentially bolster or support what's in those sections. Now, just a reminder, section 22 is what I'm going to call being called in to the ICO regime, and 24 is a request to be directed out. Now, section 22(2)(c) of the Infrastructure Wales Act essentially says that optional SIPs are in Wales and as listed in a set of regulations. So the miscellaneous provision regulations in the Schedule 1 basically has that list. So if you're not in the list, you're not an optional SIP. And so you'll fall into whatever other regime that should be. However, a lot of projects are caught by the optional SIPs, and it is worth going through those, which I think is on the next slide actually. But just to flag as well that under Regulation 5, the way in which it's drafted is it says any request made for a direction under sections 22 or 24 made by any person must be made in the appropriate form or in a form substantially to the same effect. The made by any person bit reflects what the Welsh ministers have said, that third parties can submit requests for developments to be caught by, so an optional SIP, but to be classed as a SIP and to receive a direction to call it into the regime. Now, there's another terminology which is a valid request, and that valid request can only be made by a developer. So if something isn't a valid request, i.e. the request is not made by a developer and it's made by a third party, the Welsh ministers then have to explain why they don't consider there are grounds to bring that within the regime. But it does say they may provide the reasons for it. Now, I think the issue or the risk, as I read it, is that third parties can essentially try and get schemes called into the regime. Whether that's to what end, I mean, whether it's to frustrate it from a complexity perspective, I don't know. But it's one to be aware of. And the slight concern that I have, and again, timescales, the guidance should clarify this to some extent, is at what point is your project safe, as it were, from not being called in? And at the moment, we don't have that clarity. So if you're a DNS project now and you're going for your notification, I think they are safe. They can still use it. But if you're going down the Town and Country Planning Act route, or you're going down a Harbour Act route, and you're technically an optional SIP, at what point are you free from calling? Could you be called in the day before your planning committee for a solar farm at 35 megawatts? Could you be, post resolution to grant and you're negotiating a 106 and then you get a direction under section 22? I don't know the answer to that. I think it would very much depend. It's all kind of, the discretion and what political pressure there is. But at the moment, the way the way the regulations read is that is possible. So let's just quickly go. If you go to the next slide, please, in terms of the actual list. So this is the list of the optional SIPs. So for solar and onshore wind, it's between 35 and 50. The only guidance we've got on what could be called in is a very short reference in the consultation document from September 2024 that essentially says if you're a solar farm at 40 megawatts and you're potentially going to have some significant environmental impacts, you might be subject to being called in. That's not very helpful either, because a lot of schemes may well have those impacts assessed in the EIA. And so we need a bit more clarity on that. Construction of other generating stations expected to have installed generating capacity of over 50 meg. Slight concern with this one, as I flagged in the article, is the position around battery energy storage. My understanding from reading the regs initially was that it would be included. But then I looked at the actual terminology used and the reference to section 64 in the Electricity Act, which talks about generating stations, which, amplified by case law, a generating station is very helpfully a place where electricity is generated. So, but it basically means, the creation of energy at that point. Well, BESS doesn't create energy; it stores it and then imports and exports. So, but by all accounts, the Welsh Government, as far as I understand it, they think it does fall within this regime, and that all under 50 BESS projects are optional SIPs, and everything over is a SIP. which is slightly concerning, and we need to get clarity. I have written to the infrastructure consent team and on three things, actually. One is to try and get clarity on when the guidance will come out. I think yesterday they said in plenary in the Senedd that it was due before December, which is good. I think I may have mentioned that earlier. And also I think they did receive some criticism for the way in which the regs have been drafted, because there's quite a few errors in them, as Laura picked up earlier. I mean, I think in the application regs, we've my list is, so I've got about 6 or 7 points that are sort of obviously wrong, and I don't quite know how they'd be picked up now, where paragraphs are referred to instead of regulations. Certain regulations are the wrong regulations that are referred to, but anyway, that's a drafting issue. Then we've got construction or alteration of an electricity substation. There's no clarity on that either. There's no statutory definition of an electricity substation in the context of this. In fact, I did look up even through the Electricity Act and the Energy Act around definition of substation. I couldn't find one that was helpful in any way. So construction or alteration, obviously that's very broad, and so they are all potentially subject to being called in, but we need the guidance. Underground lines over 2 kilometres in length, that again will capture potentially a lot of schemes. You know, you look at onshore wind or solar, often those underground lines are over 2 kilometres. Overhead lines under 2 kilometres, and then they have included construction or alteration of hydrogen production facilities. As I read it, if you're not in that list, you're not an optional SIP, in which case you're free from the regime. There was discussion in the consultation response from the Welsh ministers, which was released in June, around having the ability to bring something else in, almost a novel technology category, but they haven't actually included that, which did surprise me. I thought they'd keep something to the side where they have some more discretion on that point, but I can't see how it would work unless they then just change the regs. I think that's the only way I can see it being done. For transport, we've got for rail, if it's not a SIP, classed as not a SIP, so if it's under 2 kilometres and it's not a rail freight interchange, it's not PD, you could be an optional SIP, which is a significant amount of potential development caught by that. Also the same for an airport. Essentially, if you're not a SIP, then you could potentially be an optional SIP just by want of not being a SIP itself. And then it's the same as well for. Sorry, I'm just trying to find the entry for harbour facilities. So if you're not a significant infrastructure project and you're not part of a reserve trust port, if the construction or alteration, isn't a SIP and isn't in a reserve trust port, of which there is only one in Wales, I think it's 1 or 2, you could potentially be an optional SIP. So again, there's a lot of scope there to be caught by that. And then the water sort of thresholds are set out there in terms of the volume of water for reservoirs, also in terms of wastewater treatment plants and the population they're serving. All hazardous waste facilities will fall into this category as well, even if they're not a SIP themselves, they'll be optional. And then flood defence is anything over 0.5 kilometre in length. So there's a lot in there that's caught by this provision and could potentially be called in. And as I say, it's all subject to getting that guidance, which is really, really needed. The other thing I will just flag in the misregulation provisions is Regulation 8, which I think is really important, particularly in the context of what we've been discussing. And this is the power to disapply requirements of the Infrastructure Wales Act. Couple of these, which I thought were really interesting, is that if you are called into the regime under Section 22, basically the Welsh ministers have got power to disapply quite a few of the requirements that you would normally have to jump through. And I presume that, and sort of emphasises the fear I had before, is that if you are called in and you're part way through a process, like a planning process, they can say, well, you don't need to do the notice of proposed application, you don't need to do the consultation and publicity requirements. They can take it as read that that's kind of already been done. So there's a way for them to turn off aspects of the scheme that relate to these optional SIPs. And separately, there's another provision in Regulation 8 which gives them a lot of discretion as well, which is where for 18 months from the 15th of December, the Welsh ministers can, in relation to any development, direct that certain requirements of the Act don't apply to that development. So it's in respect of any development, but presumably it does mean those that are in the SIP regime, but also those that are called in. So again, it references, the PAC requirements. It references the validity process that PEDU have to go through, publication notifications. There's a huge amount of discretion again for them to sort of pick and choose which ones they think should or shouldn't progress in a certain way. Could I have a next slide, please? I think we may be getting quite close to the end now, so we have a bit of chat. I just wanted to cover this quickly, and actually, Laura, you may want to do this, but I mean, to be honest, given timing, we've gone over slightly. Sorry, I think we've been quite ambitious trying to unpack all of this, given how much detail there is. But it was just a flag that obviously when DNS goes and those provisions are removed, we'll end up in a situation where we have SIPs covered by the Infrastructure Wales Act, but things that aren't covered by that will fall back to their pre-existing regimes. So, planning permission, TCPAs, anything, say, for example, of sub 50 scheme will fall back to TCPA. Under 2 kilometre overhead line will be under the Electricity Act, for example, but then it would technically be an optional SIP as well, so it could be called into the regime. And the same goes for Harbours Act orders, Transport and Works Act orders. They'll all still be relevant. But again, in terms of a Transport and Works Act order or a Harbours Act order, if you're partway through that process and you're brought into the SIP regime, how those two regimes interplay and how they're sort of turned off, I'm not 100% sure. So we'll just have to wait and see how that works itself through. Could you go to the next slide, please, Fran? And this is it's very much the same. These slides will be circulated so you can see them, but it was basically continuing that same point. Could we have the next slide, please? I think we may then be on to. What next? So, well, we've got this 24-month transition period, albeit the main one to look at is I suppose benefiting from the DNS regime. The guidance will follow. And as I said, it was confirmed yesterday, it will be coming out before December. We're expecting a surge in projects to try and I think so are PEDU, to try and benefit or use the DNS regime. And we need to everyone needs to be mindful of potentially falling into the SIP regime if for some reason the project that you're working on can't be or that notification can't go in, and then you before the 15th of December, and you're then unable to get it into your application. You can't get in within that 12-month period of the notification. If you do potentially then slip into the SIP regime, you've got to be careful about how there could well be some crossover between the two. I touched on what the draft ICO will look like, and I also touched on the fact that we're waiting for more regulations around changing, revoking and challenging ICOs. By all accounts, the Welsh ministers are committed to providing support and training to stakeholders to make sure that they know about the process. That's fine, but as I said, there's a huge dearth in resource at the moment, and I'm not sure how helpful that can be in practice. I think they actually need bodies on the ground rather than just some training or webinars. And the fee regs and the miscellaneous provision regs were signed off yesterday, as I say, albeit slight criticisms of the way some parts of them were drafted, and I don't think they covered the points that we've picked up as we've been through them. So we'll see where we get to on those. And the others which were subject to the negative procedure, which are the application, examination and compulsory acquisition regs, I think they've got 10 days left from today, you said, Laura. So yesterday, I think it was mentioned that they pretty much will be signed off and they've had no objections to them. So what we've got and what we've talked to you today about, really don't expect there will be any change to it. So we can look forward to or working with these regulations through the SIP process and seeing if we get that clarity through the guidance.